final week, hopefully, of the session. Sue, you want to call the roll?
Representative Brady,
Here.
Representative Bratton,
Here.
Representative Chestick,
Here.
Representative Filer,
Here.
Representative Kelly,
Excused.
Representative Lean,
Here.
Representative Singh,
Excused.
Representative Webb,
Here.
Chairman Washit.
Here.
Mr. Chairman, you have a quorum.
Thank you, Sue. So in House Judiciary, we maintain proper decorum. We just treat each other with the golden rule, and never had a problem in this committee and don't expect to today. So with that, Senator, would you please introduce us to Senate File 92?
Thank you, Mr. Chairman. Good morning, House members of the Judiciary Committee, the #1 committee. You have in front of you Senate File 92, known as the Wyoming False Claims Act. What this bill does is it provides a civil remedy against individuals or entities that would choose to defraud the government through a government program or other government funds, and provides an ability for the government or an individual to seek civil redress or a civil remedy for that fraud or false claim. In exchange, that individual or entity or defendant, we would call them, and even in a civil case, could be liable for up to 3 times the amount of damages for which they may have harmed the government or falsely taken money. The individual also who brings that false claim on behalf of the government may be able to receive some compensation as a result of their efforts in pursuing the justice associated with that fraud. So how did the bill come to my attention that we might need a Wyoming False Claims Act? It really came out of the issues out of Minnesota. And so those issues are still being investigated and pursued, but from all accounts, it appears that the fraud occurring in the state of Minnesota is pretty significant, involving many individuals and a significant amount of money that has gone on for years, potentially. And so how does that get that far when fraud is illegal and there are crimes associated with that alleged conduct that may have been occurring? And some of it may have to do with people being afraid of being criminals or accusing someone of committing a crime. And so what we found in states that are larger than ours, but still have similar dollar amounts associated with government appropriations or contracts, that they have this particular tool in the toolbox, allowing individuals who may have information associated with a false claim or report, which they may have reported to criminal investigators, but just without action moving forward or anything taking place, allowing them to pursue the matter. So, Mr. Chairman, I'm happy to stand for questions on the big picture overview, and then we'll go through the bill. Any questions?
Please proceed.
Okay, so the bill is complicated. It's a big bill. It's an entire act that we're adding. So I forgive the length of the pages, but it's kind of helpful to understand big picture where this is going. It also may be helpful to understand the scenarios for which this particular civil action may be presenting itself. And I want to make sure it's very, very clear that I am not aware of any of these types of actions occurring in the state of Wyoming. So I'm just going to use an example for demonstrative purposes, but this is not suggesting or alluding to any type of criminal or civil violations that may be occurring if this bill were to pass. But an example may be in a construction contract. So how much does a Wyoming high school cost to build nowadays? Or a Wyoming highway? So Wyoming High School, we just appropriated funds in the last 2 years for that. That was about $160 million. It's just appropriated to contractors in the state to build those schools. And so in that process, it's possible that a change order or other types of documents or information could be provided in order to either get the contract or to get monies associated with that contract that were false. That they provided information that was false in order to get the contract, or they provided information that was false, suggesting that the amount of money they needed or required wasn't true. And really hard for anybody in government or outside that particular company to know the reality of those allegations. You take that information as true. So that's just an example. And again, I am not aware of any facts or alleging any misconduct. But that's the scenario that this particular law could become relevant. So we'll work through the bill. Definition, starting on page 2. A claim means any request or demand, whether under a contract or otherwise, for money or property, and whether or not the state has title to the money or property. And what that is referring to, the state has title, it could be federal funds flowing through, or it could be other types of funds flowing through instead of state monies. It could be other monies for which the state is responsible for, which you still could receive as a result of submitting a false claim. So you have to present the false claim to the government. This is to an officer, employee, or agent of the state, or is made to a contractor, grantee, or recipient if the money or property is to be spent or used on the state's behalf or to advance a state program or interest. And if the state provides, so I'm on page 3, provides or has provided any portion of the money or property requested or demanded, will reimburse the contractor, grantee, or other recipient for any portion of the money or property that is requested or demanded. So these definitions here identify how one presents a false claim to the government and what the government has to do in response, which means they have to give the money or get the contract, whatever the action may be. Page 3, line 11, a false claims law investigation means any inquiry conducted by any person on behalf of the state for the purpose of ascertaining whether any person is or has engaged in violating the act. Here we have a concept of knowing or knowingly. And members of the Judiciary Committee, you know that in the criminal law, this is an element associated with finding of criminal conduct. It's the mens rea associated with being convicted of a crime, knowingly, that intent element. That's here as well, even though this is a civil remedy. And so one thing to kind of be mindful of, this particular act or this particular cause of action is kind of a hybrid between the criminal law and the civil law. So it's kind of unique in that function. So just kind of big concepts there that get mixed, but kind of a quasi legal process. Okay, so we're on page 3, line 18. That a person knowingly means that a person with respect to information and without requiring proof of specific intent to defraud does any of the following: has actual knowledge of the information, that the information is false and being provided, right? On page 4, line 2, acts in deliberate ignorance of the truth or falsity of the information. So what does that mean, deliberate ignorance? This is a common concept in the law, that you cannot be willfully ignorant. The most common example of this that we see is actually in the criminal law, where you have an individual who is paid $50,000 to go get a rental car and drive it from LA to Minnesota. And they're not to look in the trunk. Do you think that that's suspicious, or do you think that they're just being asked to be a courier to deliver someone's Christmas presents? No, they're probably a drug mule, right? And they've been asked not to look in the trunk because that's where the drugs are located. And it's not reasonable to be paid $50,000 to drive from LA to Minnesota, a known drug route. And so we call that willful ignorance under the law, and you could be charged with possession with intent to deliver drugs. It's a very common occurrence there. So questions about that? Okay, moving on. Page 4, line 5, acts in reckless disregard of the truth or falsity of the information. Line 8, material means having a natural tendency to influence or be capable of influencing the payment. And so this says it's not just a insignificant piece of false information, right? It's not a minor detail. It's material to the receipt of the contract or the receipt of the funds. It's a significant falsity, a material falsity that was stated that caused the wrongful appropriation to occur, right? So it's not that you dated it wrong. It's not that the wrong date was signed. It has to be a material misrepresentation. So page 4, line 12, obligation means an established duty, whether or not fixed, arising from an express or implied contractual grant or grantee. So this is an obligation, means an obligation to pay as a result of the contract. So this is just an element that there is like a binding contract that occurred, or a binding arrangement that occurred between the government and the entity. Original source, and this particular concept or definition is important. It means a person who has voluntarily disclosed to the state the information on which allegations or transactions in the claim are based. And so this is the person who would be receiving later in the bill whistleblower protections or retaliation type protections, and actually is an original source of the information. Page 5, they have knowledge that is independent of and material aids to the publicly disclosed allegation. So they know it firsthand. And they voluntarily provided it to the state. So this wasn't being compelled under any kind of lawful action. It was voluntarily reported as a result of a concern of preventing fraud from occurring. Proceeds on line 8 means civil penalties and damages as provided by this act. Prosecuting authority means any official other than the Attorney General charged with investigating, filing, and conducting civil legal proceedings on behalf of or in the name of the state. Here we have here line 16, state. This is a very important definition here too. State means the state of Wyoming, obviously. Agencies, boards, political subdivisions, instrumentalities, officers, employees, including the University of Wyoming. So this could also be your local counties. So this bill contemplates county prosecutors being able to initiate these actions in addition to the Attorney General, in addition to individuals. Okay, page 6.
One moment. On page 5, Senator, under the prosecuting authority, can you explain a little more detail why the carve out for the Attorney General?
Mr. Chairman, I'm going to get that cleaned up. It does allow the Attorney General to proceed. This definition isn't clear. We looked at this in Senate Judiciary too, and it's just the way that the language is written. The Attorney General is the primary prosecuting attorney. It also allows county attorneys to move forward too. So let me work through the bill and I'll come back and explain this because there's an explanation later. Good catch, but it does not exclude the Attorney General.
Thank you.
And
Continue.
maybe we'll find an amendment to kind of just make that clarification at that point. All right, page 6, false claims liability. Any person who commits any of the following acts shall be liable to the state for 3 times the amount of damages that the state sustains because of the actions of that person. A person who commits any of the following acts shall also be liable to the state for the costs of a civil action brought to recover penalties or damages and shall be liable to the state for a civil penalty of not less than $5,500 and not more than $11,000 for each false or fraudulent claim. So why that number? It's taken from other states, and you can pick whatever number you want, but it is intended to be a penalty that is substantive, but not overly punitive in light of the treble damages or the triple damages that are allowed under the law. So page 6, line 16, knowingly presents or causes to be presented. So this is the conduct that would result in liability in the payment of triple damages, starting on line 16. Knowingly presents or causes to be presented a false or fraudulent claim for payment or approval. Knowingly makes, uses, or causes to be made or use a false record or statement material to the false or fraudulent claim. Remember, we identified that material term. 7, has possession, custody, or control of property or money used or to be used by the state, knowingly delivers or causes to be delivered less than all of that money or property. So somebody claims that the money was used for the construction project, but it wasn't, and they withheld it when it should have been returned for not being used for the project. Page 7, Romanet 4, is authorized to make or deliver a document certifying receipt of property used, intending to defraud the state, makes or delivers the receipt without knowing whether the information on the receipt is true. Knowingly buys or receives as a pledge of an obligation or debt public property from an officer or employee of the state who lawfully may not sell or pledge the property. Knowingly makes or uses or causes to be made or used a false record or statement material to the obligation to pay and improperly avoids or decreases an obligation to pay or transmit money or property to the state. I'm kind of summarizing some of those paragraphs instead of reading them to you. Let me know if you want me to slow down. Okay, page 8. This includes conspiracy, which requires 2 or more people. Line 4 is the beneficiary of an inadvertent submission of a false or fraudulent claim to the state, subsequently discovers the falsity of the claim and fails to disclose the false or fraudulent claim to the state. So you know that maybe you're the CFO, you know your CEO or some other person within the company submitted a false information. You didn't know it at the time that occurred. You didn't know it at the time the project was underway, but you found out later and you did nothing. You could be liable as well. Line 9 is the beneficiary of an inadvertent payment or overpayment by the state of funds not due and knowingly fails to repay the inadvertent payment. So the state double pays for an invoice and you don't correct that. It's a problem. Line 14, notwithstanding subsection A of this section, a court may assess not more than 2 times the amount of damages that the state sustains because of a violation of subsection A of this section, and shall assess no civil penalty if the court finds all of the following.
Senator, I think we have
Yes.
a question.
Great,
Senator
yeah.
Stasek.
Thank you, Mr. Chairman. I do have a question on, I have a lot of questions about this bill, but I have one specific one on this line right now, line 15, in subsection B. So here's where there's a double damage. If the person who received the payment does not voluntarily disclose or that's when the treble damages occur. But if there's some voluntary disclosure of this, there's the 2 times damage here in this section. And you say the court may assist. I understand this section to be if the company or an individual receiving the payment somehow voluntarily says, here's, oops, we goofed, we made a mistake, we got overpaid, then you say the court may assess. But what if they just pay it back without having to go to court? And there's no court proceeding, there's no double. Is there an opportunity for the company to simply voluntarily disclose, we got this overpayment and we're going to pay it back and no harm, no foul? Is that how this would work?
Senator.
Mr. Chairman, right. Yeah, then those other elements wouldn't be there. There wouldn't be a knowing intent to defraud. Because if it wasn't discovered, if it was inadvertent mistake, then somebody has to demonstrate that somehow they knowingly attempted to defraud.
So timeliness would be important there. The time frame in which that reimbursement was identified as being necessary and then made, right?
Correct. And Mr. Chairman, I mean, in order to get to this level, somebody has to present a lawsuit and sue. So this is not going pragmatically, and I know that doesn't provide a lot of comfort to us in our theoretical ivory tower realms. For one overpayment from the state that somebody didn't catch, right? They're just depositing the money. It's just the accounting person receiving the check, depositing it into the check, and nobody really catches it for a while. I don't think that accountant is going to accuse her employer of fraud and bring a lawsuit because one time the state gave a double payment by mistake and nobody caught it. Because the elements aren't there, it would be immediately dismissed, and the company, one would assume, would pay it back as soon as it was brought to their attention. There's some other requirements later in the bill that talk about the ability to be the private citizen to engage. And I don't think that the government would be suing an entity without initially sending them correspondence or some type of communication identifying the overpayment and trying to remedy the situation, which is another concept in law, Representative Chestick, that you're aware of, that would still apply in this civil procedure, which is mitigation of damages, right? So those concepts would still exist. So I don't think that is a reasonable concern.
Representative Chestick, follow up. Please, any further? Please continue, Senator.
Okay, so page 8, line 14, that's where we were on this section. And this is confusing because we just talked about triple damages, and here this is talking about not more than 2 times. And so this is an incentive provision. This is a new subsection. This is paragraph B, and then we go through Romanettes 1 and 2 on the next page. This says, you'll be limited in the amount of damages if after you are sued and if after it's demonstrated that you knowingly did this, you fess up within 30 days and take accountability for it, then your damages are reduced. It's this incentive to just be forthcoming after it's been proven and demonstrated that a false claim has been presented. Right, so moving on to page 9, after kind of being confronted and it being demonstrated, and that can be in the investigation or in the lawsuit, the person fully cooperates, right? Because really, this is intended to recover the people's money, right? That's the purpose. This is not a criminal case where we're intending to put somebody in prison. We're really just intending to recover the taxpayer's dollar, the people's money, and to prevent these types of activities from occurring, trying to prevent fraud. It's possible that they could be also charged with a crime associated with this, but this particular legal process doesn't touch that, and this isn't what this is about. This is about recovering the people's money.
Thank you. Please continue.
All right, so moving down on page 9, line 14, liability pursuant to this section shall be joint and several, which means that everybody's on the hook for all of the amount that may be owed. So the company is on the hook, as well as maybe the CEO if they were part of the litigation. And so everybody's got to pay. Not twice, but just the total amount. Line 18, this act shall not apply to claims made pursuant to workers' compensation. There's a different statutory remedy associated with that. Regarding the payment of sales and use taxes under Title 39, this isn't about not paying taxes properly in the state of Wyoming. There's other remedies for that. This is about those big dollar government appropriations, right? Where you are providing a false claim in order to receive something from the government. Regarding assets of a person that may be transferred to the Department of Insurance. These are just kind of wisdom that's been brought out by other states just to carve out what really this law isn't about. Regarding services requested under the Wyoming Medicaid program, again, there's already a statute, Medicaid Fraud Act, did that law in 2019, which was an update. Regarding federal welfare benefits, again, there's already a law addressing that. Line 11, regarding money, property, or services that the state has paid to a person as compensation for employment with the state or as an income subsidy, already laws about that. That would be wage and hour laws. Here's some weirdness here, starting on line 17, asked for by your telecom companies. It doesn't hurt the bill in any way, but they just want to make sure there's clarity regarding taxes and fees associated with those telephone charges that we receive. Regarding the payment of 911 emergency taxes imposed under Title 16, it doesn't hurt the bill, but they feel more comfortable with it, and I would rather they feel comfortable than hurting the bill. Regarding the payment of state universal service fund contributions, again, that's on your phone bill. On page 11, regarding the payment of state message relay services, again, on your phone bill. The lawyers for telecom really need more to do. I think these amendments demonstrate, again, it doesn't hurt the bill. I don't think it really relates, but if they want to make sure there's clarity, they're happy to provide them that clarity. And again, line 4 on page 11, local franchise fees, again, in that same type of concept. Okay. Page 11, line 7. Investigation and prosecutions, powers of prosecuting authority, civil actions, jurisdiction of courts. The following shall apply to investigations of false claims under this act. Chairman Washit, here we go. Line 14, the Attorney General or applicable prosecuting attorney shall diligently investigate violations of this act. If the Attorney General finds that a person has violated this act, the Attorney General or the applicable prosecuting attorney may bring a civil cause of action, but they don't have to, right? It's at their discretion. An applicable prosecuting attorney shall have the right to intervene in an action brought by the Attorney General under this section not more than 60 days after the Attorney General notifies the prosecuting authority of a violation. So if the county attorney wants to get involved with the AG, they can. It's limited to that. That allows the county, if the county was also receive monies or they want to just participate, they have the ability to do that. They probably wouldn't. They'd let the AG just do the work for them, but they could. Line 7, the following shall apply to civil actions brought due to violations prohibited by this act. The parties of civil action shall adhere to the requirements of Wyoming Rules of Civil Procedure. Why is this in here when it seems pretty explanatory? As mentioned, this is kind of a complex concept in that it's a quasi-criminal civil remedy, but it's really civil in nature. So just providing this particular clarity because it would be the government, usually the AG. So it'd be state of Wyoming versus somebody. Usually that looks like a criminal action, right? Where the state is going against somebody in a criminal sense. This would not be that. So just providing that clarity that this is civil nature only. And that tells the lawyers and the parties involved in the litigation that the rules of civil procedure will apply. No court shall have jurisdiction over an action brought pursuant to this act against a member of the legislature, a member of the judiciary, an elected official, or a member of any governing body if the action is based on a false claim or evidence or information about the claim was known to the state when the action is brought. Why is this here? Very important, because this particular cause of action allows for individuals to bring causes of action, except if it's against an elected official and the state knows about it. Really kind of ensuring that the proper parties to bring this type of cause of action, it can't be retaliatory, like individual attacks, right, on somebody, impugning someone else's character simply because they're an elected official. So it kind of prevents that mischief of abuse by individuals that do have the right to bring this cause of action on behalf of the government. It limits it to the government only having that authority. So I think it's an appropriate protection and is in this particular protection, or I would say wisdom, is in all of the False Claims Act laws across the country. So line 21, the attorney general or applicable prosecuting attorney shall not bring an action that is based upon allegations or transactions that are subject of a civil action or penalty proceeding where the state is already a party. So if the state is pursuing a criminal remedy, then this particular lawsuit is moot and is not allowed to proceed. A court may dismiss an action or claim under this section if substantially the same allegations or transactions were publicly disclosed in any of the following. So again, it doesn't allow somebody to read a story about somebody and then sue. That's not considered an original source. And you're not reporting something that isn't known, right? Moving on to page 14. So line 1, unless otherwise authorized by law, a court shall not have jurisdiction over an action based upon information discovered by a present or former employee of the state during the course of that employee's employment, unless the employee first, in good faith, exhausts existing internal procedures for reporting and seeking recovery of the falsely claimed sums through official channels, and unless the state failed to act on the information provided within a reasonable time. Lots of terms that make you nervous, but are common in the law. Reasonable periods of time are common in the law, because you can't legislate with specificity all of the scenarios that these circumstances may be that people on the ground may be presented with. But it does require an employee, before they can maybe take advantage of an error, to exercise their administrative rights or administrative remedies internally within the policies that the state provides, that they have to report it up the chain of command. Okay, line 11, the false claims account is hereby created. Here's a way to generate some revenue. Notwithstanding, this is another section of law, 33% of the proceeds of an action or settlement of a claim by the attorney general or a prosecuting attorney shall be deposited into the account. The remaining proceeds of an action or settlement of a false claim shall be deposited in the public school fund of the applicable county in which the false claim arose. So this is at your discretion as well. But both penalties and fines, so criminal fines, those monies go to the school. They go to the school. So this isn't anything unique that we're putting in here.
Representative Chester.
Thank you, Mr. Chairman. I have several questions about this section. I think others on the panel may have questions as well. If I had let me ask two questions in sequence. The first question on lines 12 to 14. Later in the bill, you create a bonus essentially for the relator, the person who blows the whistle and files the suit, up to 15 to 25% in some cases, and there's other issues with that. But this doesn't seem to be accounted for in the distribution. This paragraph says, how do you distribute it? There's no account here in this paragraph for paying out that first. So does the relators share whatever the judge says it should be, get paid out first, and then the rest of it's distributed this way? Or how does that get accounted for? When does that get paid out?
Senator,
Mr. Chairman, I'm assuming you're asking if the defendant pays a partial judgment, how does that get distributed? I mean, otherwise, if there's $1,000, then 33% would go into the account and the other amount would go to the relator.
follow up?
Yeah, what I'm saying is, so the relator files the lawsuit, wins, gets a verdict, and it's paid. But according to the judge will then have the discretion to decide how much the relator gets, 15 to 25%. And that would be the proceeds of the lawsuit, would be the verdict. But does the relator get their fee up front and then the rest of it gets distributed according to the 33%? Or, I mean, there's no account in this paragraph about paying the relator, whatever the judge says the relator is entitled to.
Senator,
Mr. Chairman, I don't see that as a serious concern. I mean, if a judgment is paid, then the money would be distributed accordingly pursuant to those percentages. If you're concerned about like a partial payment or payments over time and how that gets distributed, I'm happy for, I'd welcome an amendment that say it's 33% first or vice versa or 50-50 until the judgment is paid in total. I do think that's something that the court could exercise its discretion in, like it does in other types of cases, but I don't think it hurts or harms the bill regarding that. And if you'd like to bring an amendment to provide clarity about how those percentages get distributed in the event that there's a partial payment on a judgment over time, go right ahead, Mr. Chairman.
Senator, Representative Chesty.
Different topic, same paragraph. So the idea behind this bill, let me say, I totally on board with the idea of the bill. I think it's a good bill. It's a good idea. We need to have something like this for sure. I'm not sure we're there yet with some of the changes that need to be made. Why does the money go to the public school fund? It seems like if the Department of Transportation contracts with a contractor to build a road, and the contractor starts submitting false claims and gets overpaid, and there's some fraud going on, and we get a recovery. Why doesn't the money go back to the Department of Transportation? They're the ones who got hurt. And then that money would then be dealt with as maybe a reversion back to the general fund because we got money back. Why does it all go to the public schools and rather than the entity that got harmed?
Senator.
Mr. Chairman, I think the concept of treble damages may not be considered here. And so treble damages is on top of compensatory. So the compensatory damages, which makes the YDOT whole. So YDOT got falsely claimed, they were defrauded $1 million. YDOT would get $1 million back. And then there's 3 times that amount in excess if treble damages are assessed. So there's more than enough money to go around. And so consistent with all of our other statutory provisions, the public school fund is where penalties and fines go. Again, this is a question for the legislature about if you'd like to go somewhere else. I have no, I don't care where the money goes, but just to be consistent with other areas of statute and recognizing that's a fund that needs funded, didn't want to get creative with where those recoveries may or may not go. I think that's a conversation for years down the road, potentially. Once this bill gets enacted and we can see how it works, we can always change where those recoveries may be deposited. But again, it's not something I'm married to. And the only reason why it's in there the way that it is because that's consistent with the rest of our entire statutory code.
So Senator, the recoveries, as you call them, are they not considered fines as the Constitution defines them? They're not. Very good. Representative Chesty.
Thank you, Mr. Chairman. So I think Where I got confused, and maybe others would be confused, is on page 6 now, page 6, line 6, the treble damages. There's no indication that the treble damages are in addition to compensatory damages. I didn't see that when I read through it, and that so maybe to clean up the problem on page 14, we also need to clean up on page 6 that the treble damages are a penalty in addition to compensatory damages. Why, you're shaking your head, why not?
Senator.
Mr. Chairman, I think treble damages are not considered penalties. I think they're considered treble damages. So 3 times the amount of damages sustained. It would include compensatory. 3 times the amount of damages sustained.
Right.
And so that is what could be assessed in a civil judgment. That's separate and apart from a penalty.
Okay.
Through the chair, please. Representative.
Thank you, Mr. Chairman. So you said earlier that the compensatory damages would go back to the Department of Transportation in my hypothetical, and then the treble damages would then go to the school fund, which means they're paying 4 times. They're paying the damages, and then so I guess we need to clean up the treble damages. If treble damages include compensatory damages, we need to amend the statute to clear up where the money goes. The money goes back to the agency that's been harmed first, and then the excess will go into the school fund.
Senator.
Mr. Chairman, yeah, so treble damages as interpreted by the False Claims Act, which is the federal law of which a great deal of this legislation is based upon. And treble damages being a concept in many different areas of law, but as it applies to the False Claims Act, it's 3 times the government's loss. So it would be 3 times YDOT's loss. That's treble damages. So it's a lot. So if you're talking about $160 million school, 3 times that. So there's a lot of money to go around. And this is a type of cause of action that would be significant damage, right? That would be worth pursuing. So I think that the concern over who gets paid first is a good one. I'm not sure it's something that the courts are currently dealing with, allowing for attorney fees and allowing for other remedies, including penalties and treble damages and many other types of civil causes of action where they just assess those. If you want to provide clarity that the relator gets paid first and then 33% goes into the fund to pursue additional causes of action, you know, again, that type of an amendment is welcome. I don't know that it's a weakness or a deficiency in the bill. But if you'd like to provide that additional clarity, we certainly can do that.
Representative Shestak, anything further?
Yeah, so I just want to clear up a potential misunderstanding. If the contract for the school is $160 million and there's a false claim, that doesn't mean that the damages are $160 million. It's the overpayment. The damages are the overpayment. So they really spent $150 million and they overcharged $10 million. That's what's being troubled is the overpayment, not the whole amount.
Mm-hmm.
Right. And so that's why it seems to me that we need to clarify that the overpayment goes back to the agency that lost the money in the first place. And then the excess gets paid out however we get paid out.
Yeah, and Mr. Chairman, some of these examples I've given are purposes of simplicity. And so the damages sustained by the government, and so whatever the damage is proven, whatever was falsely taken based on that material misrepresentation is what the damage would be. So it may not be 160 million, but I'm just throwing that number out as demonstrative to talk about the type of numbers these type of causes of action are dealing with. Theoretically, it's significant, and this is not intended to be pursued for $5,000 because somebody misdated something, that there's other more judicious remedies in order to receive that compensation back. That these are pretty sophisticated frauds that have taken a significant amount of the taxpayers' dollars that would justify the amount of effort that would go in to take on this type of litigation. Again, treble damages and penalties are not unique in the law, and our courts are well versed in understanding how to deal with the distribution of how those damages awards are made. And you can legislate that prescriptively in statute, or you can leave that to the judge's discretion at the time of award is issued. Whatever is the will of this committee. Again, I don't think it's actually a significant concern.
Very good. We're at 9 o'clock, so let's keep moving through the bill.
Thank you, Mr. Chairman. So on page 14.
One moment, Representative Bratton, I'm sorry.
Yeah, well, I'm sorry, yes.
Thank you, Mr. Chairman. While we're still there, I have a question about this section also. So under the Federal False Claims Act, recoveries are deposited into the US Treasury, and then the whistleblowers receive their statutory percentage. And of course, the the DOJ is funded through congressional appropriation. So there's not an automatic percentage being continuously appropriated. So my question on page 14, line 20, is that the funds are, in this bill, the funds are continuously appropriated to the Attorney General. That's not typical in the other 33 states that have similar legislation to this. So I'm curious, my question is, yeah, I don't like that. Tell me your thinking behind making the continuous appropriation to the AG office rather than to the general fund where it's not under legislative approval.
Senator.
So, Mr. Chairman, I think let's break down the words on line 19. Funds in the account. So this would be funds that the Attorney General has recovered on behalf of the state. That's the only monies in that account. Upon appropriation by the legislature. So the JAC, through then full legislative action, is the only body that is able to appropriate funds out of that account wherever they may go. So you can strike from shall to may, be continuously appropriated to the Office of the Attorney General right to pursue these actions. So it is actually in other states. This is not I did not create anything new in this particular act. As creative as I am, I'm not. Lawyers aren't encouraged to be creative. We're encouraged to adopt what other people have known to work and be done. So if you're concerned about this particular issue about how the funds in the account are to be utilized subject to the appropriation by the legislature, if that's not enough, you may strike the word shall to a may. And that solves, I think, any concern that may exist there. It does make sense to me in the case, again, treble damages. So the state is intended to be made whole from the false claim. To go to the Attorney General for resources associated with pursuing these cases. And again, if we go on to page 15, line 2, limited to the purpose of being used by the Attorney General to support the ongoing investigation and prosecution of false claims. So it's intended to be kind of a self-sustaining fund for the purposes of identifying future claims. Again, subject to the appropriation of the legislature. So if the legislature finds that there's enough money in that account and it should go elsewhere, they can send it elsewhere, like we do every year. We can change that around. We have that final say.
Please continue.
All right, page 15, line 6. Be used to reimburse a prosecuting authority for the investigation and prosecution of false claims pursuant to this act. So again, those counties who want to take action on this, that the Attorney General may not have interest in, that may not be of sizable action that the Attorney General will take interest in, but the county wants to pursue it. Maybe it's for $100,000. They want to go try to get recovery. They may be able to seek reimbursement, not only from the defendant in the case, but from this fund for costs or even investigative help. So if they need to hire experts in order to pursue the matter, forensic accountants, et cetera, they would have some resources available that many of our smaller counties just wouldn't have in order to pursue these types of investigations. So page 15, line 10, Unless otherwise specifically provided, not lapse or revert at the end of the fiscal period and shall remain in the account. Again, if you feel uncomfortable with that, you can strike it, but I would identify where any funds should revert to. But again, it would just remain in that account, and that provides some transparency for the legislature to see what's in there and shall not be appropriated except subject to legislative appropriation. So lots and lots of protection. You know, interest or other earnings and funds with the account to be credited back to the account. Again, I don't anticipate this fund to be that high over time in light of where all the monies need to go. Okay, so page 15, line 17, this involves the individuals, not just the government taking action. In addition to the remedies provided, which is the government action, any employee, contractor, or agent shall be entitled to all relief necessary to make that employee, contractor, or agent whole if that employee, contractor, or agent is discharged, demoted, suspended, threatened, harassed, or in any manner discriminated against in the terms and conditions of employment because of lawful acts done by the employee, contractor, agent associated in furtherance of this act. So if somebody, this would be a whistleblower, most commonly understood. So somebody who is aware of this, of the fraudulent activity, takes steps to report it, uncover it, and is retaliated against or loses their job or suffers some type of adverse employment event, they have protections. These are those employment protections. They get reinstatement, they get back pay. This is similar with other remedies in employment law. Okay, page 17. This is important. This is regarding the ability of individuals to bring these causes of action, which is a pretty significant and unique thing. I'm going to go to line 6. A person who may bring a civil action for a violation of this act on behalf of the person and the state. Any action brought under this subsection shall be brought on behalf of and in the name of the state. So an individual can bring a cause of action on behalf in the name of the state. It's a big deal. How are they able to do that? Lots of prerequisites in order to do it. The action may be dismissed only if the Attorney General or prosecuting attorney give written consent to the dismissal and the reasons for consenting. A copy of the complaint and written disclosure of substantially all material evidence and information the person possesses shall be served on the Attorney General and the prosecuting attorney. Okay? So before the individual can do this, they have to give a copy of everything that they have, the litigation that they intend to file, to the Attorney General or the prosecuting attorney. They have to do it privately, confidentially. The complaint and written disclosure shall be filed in camera. That's what that means. Shall remain under seal for not less than 60 days. So that gives the Attorney General or prosecuting attorney 60 days to evaluate the evidence. It shall not be served on the defendant until the court orders an action. So the court has to authorize that individual to bring the action on behalf of the state. The Attorney General or prosecuting attorney may elect to intervene and proceed with the action not more than 60 days after the Attorney General or prosecuting attorney receives the complaint. So, questions about this?
Senator,
Okay.
Yeah. I understand the state bringing these actions, but then on page 17, we start talking about private persons bringing these actions and bringing these actions on behalf of or in the name of the state. So Joe Citizen files a lawsuit on behalf of the state of Wyoming under this act. Can you
Yes,
help
Mr.
me
Chairman,
there,
did you know
please?
that you could do that on behalf of the United States of America right now? You, Joe Washit. You, Joe Citizen, we, Joe Citizens, can bring a lawsuit on behalf of the United States. That's what it would say. Tara Nethercott, on behalf of the United States of America versus ABC Company or Joe Smith. You can do that right now. If you know of fraudulent activity that's been provided to the government in exchange for and received by that individual or company, right?
I learn something new every day.
Yeah,
Thank you, Senator.
so much power we have as citizens of the United States. That's called the False Claims Act. And the purpose and why that's there is to encourage people to report, right? Rather than always a criminal investigation. And it allows those individuals who really understand the facts and have worked to do so and may feel frustrated as a result of the if you can imagine the circumstances that an employee may find themselves in, if known that there is this type of activity underway and no one has done anything about it, what needs to take place? Again, before they're able to do so, they have to get court authorization and they have to let the proper authorities have the information and the ability to proceed to exclude that citizen, right, to take over on behalf of that citizen. So it's a pretty impressive right, but the purpose really is to catch that fraud.
Representative Shestak.
Yeah, and to me, this is the heart of the bill. And this is the part I like, because how are you going to find out about fraud? You don't want government having to constantly audit private companies all the time. You know, big government can't really do that. Who knows about the fraud? People inside the company, right? So it's the bookkeeper or the accountant who sees what's going on here, and they're the ones who know what's going on, and we need to incentivize them to do this. So this to me is the heart of the bill. I have some questions about it later on, but I think this is the most important part of the bill, and I think it's the part that we need to keep.
Representative Lane.
Thank you, Mr. Chairman. My question is at the bottom of 15 and running into 16, do we anticipate there to be a conflict because we are a right to work state with an employee that does come and blow a whistle, that they may find themselves in an uncomfortable situation with their employer at that point? How would we then be able to help that employee because we are a right to work state?
Senator.
Mr. Chairman, so the concept of right to work simply means your employer can terminate you at any time for any reason, subject to laws, other laws. So they can't terminate you for a violation of the 1964 Civil Rights Act. That would still be unlawful. And so they could not terminate you for being a whistleblower and reporting this type of crime. That would be unlawful. So right to work does not mean they can terminate you for unlawful reasons. So there's still exceptions to what that means.
Other question? Please continue. 9:15.
I know, and I have a 9:30, Mr. Chairman, so I appreciate the time. So again, here's the kind of protection. So before the expiration of the 60-day period, any extensions obtained under this subsection, the Attorney General or prosecuting attorney shall proceed with the action. Right. So really, what we really want to happen here is for the Attorney General or prosecuting attorney to take over the action. That's what would be the preferred course, right? And so that's why the law is favoring that outcome. So we want them to proceed with the action. It shall be conducted by the Attorney General, the prosecuting attorney, or notify the court that it declines to take over the action, where the person bringing the action shall have the right to commence and continue with the action. So the AG or the prosecuting attorney has to notify the court that they say, we're not going to move this case. We're not interested in this. We're not going to pursue it. At that time, that the AG or the prosecuting attorney, and they're required to notify the court, not the party, but the court, that that they decline prosecution, civil prosecution. That's the only time that the individual can move the case forward. That's the protection. When that does happen and a person brings an action under this subsection, no person other than the Attorney General or prosecuting attorney may intervene or bring a related action. That really just kind of helps control the scope of the potential litigation. So here's where if the Attorney General or prosecuting attorney proceeds with and prevails in a civil action brought by a private person, so they did all that work to prepare the litigation, they provided notice to the court, they provided that notice and they're at that stage, and that's probably a significant amount of cost and time because an attorney would have prepared that. And so they have invested a significant amount of their own resources. And this is in that scenario that person shall receive not less than 15%, but not more than 25% of the proceeds of the action or settlement of the claim, depending upon the extent that the person contributed to the prosecution of the action. Any payment to a person made under the subsection shall be made from the proceeds of the civil action. The person shall also receive compensation for reasonable expenses that were necessarily incurred by the person, plus reasonable attorney fees and costs, all of which shall be awarded against the defendant. So this is very common in civil law and civil causes of action. So you go to trial on the car crash. We determine liability and the amount of damages done, and then there's more than likely another hearing to establish what the attorney fees and other costs associated with the prosecution were. So this is a very common process in the civil court. So there's nothing unique here. Okay, page 20. If the attorney general or prosecuting attorney does not proceed with a civil action brought by a private person, and the person bringing the action commences and continues with the action, the court may award the defendant reasonable attorney fees and expenses if the defendant prevails in the action, and the court finds that the claims of the person bringing the action was clearly frivolous, clearly vexatious, or brought primarily for the purpose of harassment.
Representative Chesty.
Thank you, Mr. Chairman. I have a big problem with this paragraph because it only talks about what happens if the defendant prevails. It doesn't say what happens if the relator prevails. In the federal statute, and I'm guessing other state statutes, in this situation where the relator is the one taking the lead in the litigation and they prevail and get a verdict, they get a bonus up to 30%. They get actually a bigger bonus than they would if the attorney general had prosecuted it. That's not in here. So if you lose, you might be subject to getting sued yourself for frivolous lawsuits, but if you win, there's no bonus. So that needs to be fixed.
Senator.
Mr. Chairman, fix it. Representative checks it. Fix it. Looks like you have that statute right in front of you to adopt. I'd encourage an amendment.
Please continue.
All right, that really is the bill. Page 20, here's some of those civil procedure limitations. There's a 3-year statute of limitations that exists. We're familiar with that in the civil law. Here's some clarity on page 21, line 10. Notwithstanding any other provisions of law, a judgment or guilt in a criminal proceeding charging false statement of fraud upon a verdict after trial or upon a plea of guilty shall stop the defendant from denying the essential elements of the offense in any action brought pursuant to this act. So caution, right? Yeah, the remedies in this act are not exclusive, right? That you can pursue all remedies available at law. That's just kind of a savings clause. Happy to stand for questions. I know that this was a tough bill on the last week of legislature, tried to get it to you sooner. Senate File 92, 4th week of session. Here we go. But that's the bill. There is an amendment from some individuals in the room. I've looked through them. I think you have them in your packets. They've been handed out. I have no objection to those amendments. They are consistent with the Federal False Claims Act. And there's a desire to be as closely consistent with the Federal False Claims Act as possible, just because that brings consistency in how those cases have been interpreted over time in our courts. And so any effort to align more closely with the Federal False Claims Act is not anything I would object to.
Thank you. Committee, questions for the senator? Just know we have other people in the room who want to testify, and I think some on Zoom who may also be able to help us understand the act that's before us. So in the interest of time, keep our questions tight and focused. Any further questions for the senator? Seeing none. Have you brought witnesses in the room or nope? All right, very good. So anyone else in the room wishing to testify with regards to Senate File 92? Good morning. As usually in a budget session, time is not our friend, but this is an important act. We need good information. So please identify yourself for the record. Tell us what we need to know about Senate File 92.
Good morning, Mr. Chairman, members of the committee. My name is Jody Levin. I'm here on behalf of Charter and Verizon, just to provide some clarity about why the inclusion of the telecom taxes in this bill. So your communications industry acts as a tax collector for the government at the local level, state level, and at the federal level. Unfortunately, telecom taxes are very complex. So depending on how you are organized, some of the services are subject to a tax, others may not be subject to a tax. And as technology continues to evolve, you can have a company offering services that another company offers and they're taxed one way, but they're taxed differently by this other company. So there can be confusion that arises in taxation of the telecom industry. So why am I here? Because this has been an issue in other states, unfortunately. So what can happen is the government entity is the one who audits the books of these companies. And there have been situations where either an under or overpayment of a tax has occurred. When that happens, then the entity goes to the industry and says, we believe you've under collected or you've over collected. It gets addressed. I think that would probably be the situation that happens in Wyoming. We have a great relationship with the Department of Revenue. But unfortunately, in some other states, what has happened is a false claim has been issued on that company and they've been assessed millions of dollars in fines. So that's why as the bill was drafted, it excluded sales tax, but it did not exclude use tax and it did not exclude the telecom taxes. And so that's why I went to the bill sponsor and asked for her support in adding those elements to the bill.
So you're happy with the bill as written now?
Mr. Chairman, I really can't opine on the bill itself, but I do appreciate the willingness of the bill sponsor to include those provisions.
Very good. Questions? Seeing none?
Thank you, Mr.
Thank you
Chairman.
for being here this morning. Others in the room wishing to testify on Senate File 92?
My name is Dale Steenbergen. I'm CEO of the Greater Cheyenne Chamber of Commerce, the Wyoming Chamber of Commerce, and the Wyoming Retail Association. So we had several of our folks reach out. We're going to keep talking down this tax issue. So the federal false claims doesn't include the tax. There is a whistleblower policy through the IRS that handles that separately. And the reason for that is that tax policy is very, very complicated. And a third party, either a citizen or even somebody in the government that is not constantly working on tax policy, it's very difficult for them to see that and understand that. And often, as the previous speaker just said, there are overpayments, underpayments, stuff that has to be worked out over time in accounting. That must be taken into consideration. Certainly some other states, Illinois and New York, have included tax remedies in their false claim. I don't want to use a big word like remedy, but have included taxes in their False Claims Act. So really that's our concern, is just we would like to see something done to just remove the tax piece of this False Claims Act. We are certainly for if there is fraud going on with government on contracts, other things, to be able to take advantage of that. But we do have some of our members that are concerned on that.
Questions? I do appreciate that comment. Thank you for being with us. Senator, you want to respond to either of these?
No, Mr. Chairman, the purpose of the bill really isn't connected to taxes or any types of fees or assessments. Really the purpose. And so if those carve outs are requested, again, I don't necessarily object to those. Again, the purpose of the bill, and I understand there's historical concerns of cases in other states where the legislation or the acts have been used in more creative ways. But the purpose of the legislation, right, is to prevent people from providing materially false information to the government in exchange for government funds, right? That's the purpose of it, not to cheat the government out of what may be owed to the government. So kind of very subtle differences there, but very distinctive when it comes to what the intent of the legislation is, which is to deter and prevent people from actively trying to take from the government proceeds fraudulently. And because I do think there's other remedies associated with taxes, as was clearly identified, just like the workers' compensation claims and the Medicaid fraud. There's already good legal processes in place to remedy those actions. So no concerns over taxes.
Thank you. Anyone else? Representative Bratton?
Thank you, Mr. Chairman. Yeah, while you're on the topic of the Medicaid program, I think you did mention it, and maybe I missed it or I didn't write it down fast enough, but I know you said that one of the reasons or your thoughts for bringing the bill had to do with what happened in Minnesota, but then the Wyoming Medicaid program is carved out. Could you repeat how that's taken care of?
Mr. Chairman.
Senator.
Yeah, the Minnesota case, I don't think has to do with Medicaid as much as it has to do with some other federal funds appropriated. But Wyoming has the Wyoming Medicaid Fraud Control Act. I don't recall when that was originally passed, but I know that I did the modernization with the Attorney General's office, which was passed again in 19. And so we already have a legal remedy in place prohibiting fraud on Medicaid funds. That's both at the federal law and at the state law. So you can Google, if you have your computers up, the Wyoming Medicaid Fraud Control Act, and you can see that legal process associated with that.
Follow up.
Thank you for that. And also on page 11, line 4, tell me about the local franchise fees also being excluded.
Senator.
Mr. Chairman, this is part of that telecom. This is what the telecom providers assess in their phone bills to you. That we pay. We pay franchise fees associated with our telephone bills. This is all part of that. So it's not a franchise like McDonald's. It's a franchise like for telephone services.
Okay, anyone else in the room wishing to testify on Senate File 92? We have somebody online, Sue?
Mr. Chairman, we have Carrie Silverman.
Please bring Mr. Silverman in, please. Good morning, Mr. Silverman. We're kind of up against the clock.
Understand.
Want us to know, introduce yourself first and who you represent, and then tell us what we need to know about this bill as succinctly as you can.
Thank you, Mr. Chairman and members of the committee. My name is Carrie Silverman, and I'm here on behalf of the American Tort Reform Association. That's a broad coalition of businesses, associations, and professional firms that share the goal of having a fair and balanced and predictable civil justice system. ATRA respectfully opposes Senate File 92. Our greatest concern are the provisions that deputize private individuals to step into the shoes of the state, to bring their own actions, and then to take a portion of the state's recovery. In our experience, provisions of this kind are problematic. Here, a private person would be entitled to 15 to 25% of the state's recovery, and the lawyer for that person would also get paid their fees and expenses on top of that. So what's bad about that, you might ask? Aren't we against fraud? Yes, but you have to take into consideration the broad conduct that's covered by this bill, the extraordinary threat of liability that it presents, and the fact that the bill hands law enforcement power over to private individuals and lawyers. Just 3 points for you to consider as you're looking at this bill. First, I think it's important to recognize that, despite the name of the bill, it applies beyond fraud. In fact, the bill specifically defines knowingly or as not requiring specific intent to defraud. Rather, submitting information to the government that's incorrect may give rise to a claim, and a private person can bring an action stemming from what might be a dispute over the terms of a contract, the interpretation of regulations, or if a business has signed a blanket statement in a contract with the state affirming that the company will comply with all laws and regulations when there might be some technical issue with how they did so. Second, the potential liability under this bill is extraordinary, as we've discussed today. Not only is the company subject to triple damages in every case, but the bill includes civil penalties on top of that between $5,500 and $11,000 per violation. Even if the state had little or no financial loss from the conduct at issue, the liability can be huge. And that's because they're per violation penalties, and they might be applied to every product sold to the government under the contract or every reimbursement processed across thousands of transactions. And these penalties can potentially add up to hundreds of millions of dollars. There's no limit in the bill on how many violations can be aggregated or guidance on how you count the number of violations. Third, these concerns that we have would be partially alleviated if the Attorney General and government prosecutors were responsible for bringing the actions. They're at least accountable to the public. But the bill deputizes private individuals and lawyers who have a profit motive in getting that bounty to do so. And under the bill, if a private person brings a claim, the Attorney General has two choices: to conduct the action themselves or to decline to conduct the actions and allow the private person and his or her lawyer to pursue it instead. There's no choice number 3 in the bill, which would be for the Attorney General to find that the action shouldn't be pursued at all. Under the bill, even if the Attorney General reviews the complaint, the evidence submitted along with it, investigates, and finds that the business did nothing wrong, the private plaintiff can continue to pursue the action in the name of the state anyway. So what will a business do when a false claims action is filed against them, knowing that they face treble damages and unpredictable, unlimited, per violation civil penalties? What they may do is, given the extraordinary risk, is settle regardless of the merits. And that's our concern. So we ask that you not favorably report this bill in its current form. I welcome your questions and thank you for your patience.
Thank you, Mr. Silverman. Committee, any questions for Mr. Silverman? See none. Don't see any questions. Mr. Silverman, thank you very much for joining us this morning. Anyone else? I think that's it. We're going to close public comment. It's 9:30. Senator, bring us home.
Mr. Chairman, thank you. I think I've never heard of the American Tort Reform Association, and I never heard from Mr. Silverman, and I've been practicing law for 16 years. So not sure who they are, who they represent. Don't appreciate if they are representing lawyers, the way they disparage lawyers and the fact that they may do something falsely. So certainly not a respectable member of an officer of the Wyoming courts, indeed. But I digress before you. Any allegation that the bill, quote, deputizes any individual for wanting to seek redress for what would be fraud against the government, I think is a gross mischaracterization. As we walk through the bill, it requires the Attorney General to be notified confidentially and then allows the Attorney General or the prosecuting attorney to take action and to decline prosecution. And so really, the process is intended for those authorities to pursue the matter. And it kind of pushes them along to say, hey, this litigation has been prepared. Here's the evidence that we see. We'll go forward on the merits. If you don't do this, we will, right? And so it really kind of puts the onus on them to take the necessary action and perhaps provides the resources that those particular entities may not have, particularly your local county governments. That said, if you remember Representative Chestic's concerns where he said, wow, I really don't like it that if the AG or the prosecutor declines to pursue the case and the individual is allowed to proceed, they get really no recovery, particularly if they are found to lose, right? And the litigation was brought forward frivolously or vexatiously. And they may be required to pay fees. So I think there's which Mr. Silverman failed to identify or address, there's a strong deterrent for an individual to proceed without the support of the government, where they could be responsible for paying fees for frivolous litigation. And they may be without really any real remedy for pursuing the matter without a good amendment from Representative Chestic. So with that, I would urge your favorable consideration of this bill and recognize that maybe these types of cases and these types of concepts are unfamiliar to you. And that's where the danger lies. Because if you don't think that some of this type of conduct hasn't occurred in the types of appropriations that this state spends and puts out, I think we are maybe a bit naive to what could be occurring in light of the large public dollars that are being expended throughout our state. And so it may be our lack of familiarity with that type of conduct, which creates the disconcern, but it doesn't mean it's not present or doesn't exist and that this remedy shouldn't move forward. Thank you, Mr. Chairman.
Thank you, Senator. Committee, what's your preference? Moved by Representative Singh, second by Representative Filer. Amendments on the bill. Let's work through the page by page. Page 1, any amendments? Representative Chestic.
Mr. Chairman, I have a lot of amendments here that I would like to spend some time working on, so I'm not going to bring them up here. There's a lot of gaps in the bill that need to be addressed. And I don't know if we want to do that in a first committee standing committee or a committee of the whole amendments or second reading amendments. I don't know when to bring them. I don't know if I have enough time to get them all together, given everything else that's going on right now. I'm wondering, should we defer the bill until the interim? Because I think there's a lot of work that still needs to be done, I think, to make this bill. I love the concept of the bill. I think we need to have this bill. I want to do it right. And I think there's a lot of work to be done to make sure we get it right.
So today is the last day to move bills out of committee. So like keep that in mind as you consider whether bringing amendments in this setting or at a later setting. I leave that to your own discretion. Further amendments today, page 2, page 3, page 4, page 5, page 6, page 7, page 8, page 9, page 10, page 11, page 12, page 13, page 14. Representative Chesed.
And here's where I think I have a lot of problems in paragraph C. The distribution of the relator's fee, the 15 to 25%, and maybe 30% if we go the. I need to work this out. I think it's a very problematic. I'd like to hear other people's thoughts on what needs to be done here before I draft an amendment. I don't think I can do one here, sitting here at the table, but if other people have thoughts about this, I'd love to hear them so we can maybe jointly draft a committee of the whole amendment for later consideration.
You know, my first thought was if the school fund, if these recoveries were seen as fines, that's why I asked the question of the senator, if these recoveries are classified the same as fines, then they have to go to the school fund. But if they're not, then it's completely at our discretion to identify where those funds go. And so Representative Chesapeake's question about a highway project, given the shortfall in our highway funding, it would seem to me prudent that any recoveries due to something like this might be a great way to augment the highway fund rather than, going to the school fund. Representative Chesed.
So this relates to some of the questions I was asking the senator. The problem I have with this is that the proceeds, on line 13, we use the word proceeds, and we're not allocating the proceeds between compensatory damages and penalty. And I wasn't satisfied with the answer. I think we need to clarify how much of the proceeds are compensatory, how much are penalty, and then how they would distribute the penalty over above what do you do with the relator's fee? There's a lot of problems here that we need to resolve. And I'm not sure we'll be able to do it. I'll give it a shot, but I'm not sure. Yeah, I just need to work on this.
Further amendments on discussion about amendments, at least on page 14, page 15, page 16, page 17, page 18, page 19, page 20. Representative Chesed.
And again, this is the one that we need to clarify what happens if the relator prevails. Did they get to the 25-30% that the federal key tom statute allows? So I have an amendment here, but again, I don't have the language. Anybody has any thoughts on this? I'd love to hear them and work with anybody who wants to make this amendment with me.
I think that could be a worthy amendment. Okay. Page 20. Page 21. And our last page, page 22. Seeing no amendments, general discussion, Representative Filer.
Mr. Chairman, I was just wondering, because we did hear testimony that this amendment that was presented to us was very friendly, and it helps some others folks in the industry and aligns us with more of the federal FCA Act. So I wonder, Mr. Chairman, if it'd be okay if we go ahead and adopt this amendment.
Okay, is that a motion?
It's a motion.
Is there a second by Representative Singh? Discussion on the amendment, Representative Chestic.
Thank you, Mr. Chairman. I think these amendments are fine. They clarify some points. I have no problem with them. They don't hurt the bill. They don't solve all the problems with the bill, but I would be in favor of supporting these amendments.
Further discussion on the amendment? Saying none, all those in favor of the amendment, say aye. Aye. Those opposed, no. The amendment has carried. Did you have a copy of it? Very good. Further discussion on the bill?
Mr. Chairman.
Representative, we'll go to Representative Webb, then we'll back to Vice Chair Singh. Representative Webb.
Thank you, Mr. Chairman. I have some concern, just simply that this, the presenter spent a significant amount of time presenting this bill, and I believe she even referred to it as complex. And I feel that that there's some pressure on us that this is being rushed. And that would be my comment that I would like to hear other discussion about.
Further discussion? Representative Singh had his hand up first.
Thank you, Mr. Chairman. Sort of piggybacking off of that idea, I think that if the majority floor leader were here in the room to address some of the questions that were posed on potential amendments, we would have been able to potentially work on something that would have made the bill better in some way, maybe kind of would have eased some of the tensions out there. And this is just the nature of the budget session. We are in a time crunch. My preference would be to see this bill pass committee and then have the opportunity to have a conversation with the senator, the sponsor, to fix it, because these are valid concerns. But I'm a big fan of big ideas. So that's my thought.
Representative Bratton.
Thank you, Mr. Chairman. Although conceptually recovering taxpayer money, and encouraging people to report fraud, I'm certainly in favor of that. But I just think that this bill needs a lot of work, a lot of amendments. And so at this point, I'd love to see it as an interim and have more discussion on that. But I think the time constraints of the budget session, we're at the end of the line on that. So that's my thought. Thank you.
And just for the committee, a reminder that the time for interim topic suggestions has passed. Representative Chestic.
Thank you, Mr. Chairman. And I agree that this bill needs a fair amount of work right now, and I'm not sure we have time left in this session to accomplish that. There is no emergency that I'm aware of here. The federal key Tom statute on which this is based has been around since the Civil War. We haven't had a bill like this since the Civil War, since all of statehood. So there's no emergency to get it done this year because nothing's changed. So I'm amenable to maybe postponing action. I don't want to kill the bill, but I want to, because I think the concept is a good concept. I think we should have something like this, but I think we need to work on it some more, and there's not time left in the session to do it. I would be happy to, I understand that the time for interim topics submission has passed. I'm not sure we need an interim study topic. We just need work during the interim between interested parties, and I'm an interested party. I'd be happy to work on this. and to get it right and bring it back as an individual bill in the general session next year. So I would be, in fact, I'll make the motion to table the bill, and which I know will kill it for this session, but at least we're not defeating it. And that way we can work on it as individual legislators over the interim.
Is there a second? Second by Representative Bratton. Motion to table. Please call the roll.
Mr. Chairman, this is a motion on Senate File 92 engrossed as amended to table the bill. Representative Brady. Aye. Representative Bratton.
Aye.
Representative Chestick.
Aye.
Representative Filer.
Aye.
Representative Kelly.
Excused.
Representative Lean. No. Representative Singh.
No.
Representative Webb.
Aye.
Chairman Washit.
No.
Mr. Chairman, you have 5 ayes, 3 noes, and 1 excused.
So with the motion to table with no time certain to take it off, concluding our committee work for this session, the bill will be returned as or held within the committee tabled. And that concludes our committee's work for this budget session. So thank you all very much. Appreciate it.